Welcome, everybody. Welcome to today's episode of the Law of Self-Defense. Thank you all for being here today. I am, of course, attorney Andrew Branca for Law of Self-Defense. Thank you. Thank you so very much. So today we're here to talk about some updates in the Alec Baldwin, Halyna Hutchins shooting manslaughter case, what ought to be a manslaughter case, happened back in 2021. The fatal shooting of Halyna Hutchins by Alec Baldwin. I started covering this case the day after the shooting happened, and I've been covering it ever since through its ups and downs. And I'm going to share some of those, some of that past analysis with you today, as well as update all of you on where things stand currently. This is in the news right now because although, of course, Alec Baldwin is involved in the death of Halyna Hutchins, he was holding the revolver that shot and killed her. There's another person with criminal liability here, potentially, certainly being charged criminally, and that is Gutierrez Reed. Hannah Gutierrez Reed was the armorer on the set, young woman, daughter of a very famous Hollywood movie set armorer. This is one of her first jobs, maybe her first job as an armorer on set. And obviously we know that a live round was on set. It was in the revolver that Alec Baldwin was handling when he shot and killed Halyna Hutchins. And so the question is, does Hannah Gutierrez Reed, the armorer, bear criminal responsibility for the death of Halyna Hutchins as well? Was it her responsibility to ensure that this could not have happened? So she's about to go to trial, and her lawyers are raising a number of legal arguments in her defense, one of which is that the conduct of Alec Baldwin was in unforeseeable intervening cause between any misconduct, criminal misconduct on the part of Gutierrez Reed and the death of Halyna Hutchins, and that unforeseeable intervening cause cuts off her criminal liability and shifts it entirely onto Alec Baldwin. Before we get into that, however, I do want to share a couple of anecdotes with you, or little things that have come across our desk. First of all, Palmetto State Armory. Stop. You got me again. You got me again today. Placed another order with Palmetto State Armory. Not going to tell you what I ordered, but damn, they have some unbelievable deals. If you're an American citizen, law-abiding, mentally sound American citizen, and you do not yet have an AR and a 9mm pistol, you're doing it wrong, man. Assuming, of course, it's legal in your jurisdiction for you to possess such items. There's no excuse in 2023 for any law-abiding American citizen not to have an AR and 9mm in their home if they want one, given the unbelievable cost efficiencies that Palmetto State Armory brings to the market. It's amazing. And they're having Labor Day sales right now, already started. So something to think about if you're in need of the fundamental tools of a free citizen in America. The second anecdote I wanted to share, and I have to be kind of circumspect with this because this just occurred, but we got a call into the office this week from one of our Law Self-Defense Platinum members. Platinum members are the only people who are eligible for legal consult by Law Self-Defense, my legal consult services, if they're involved in a use of force event. And this person, I won't even identify them. Let's see. By gender, is a Law Self-Defense Platinum member who was just involved in a use of force event. And they called our office for two reasons. One, just to inform us that this event had occurred and to make us aware that a consult may be necessary. It doesn't look like it will be necessary. It looks like the Self-Defense Act was so clean that, in fact, not only is our platinum member not charged, but the other parties have been criminally charged, and our member has been called as a witness to their court appearance. So we don't expect that we'll actually need to do a consult in this case, because we don't expect that the member will end up being criminally charged. But the other reason they called, besides just informing us, as we appreciate, so we can put it on our radar screen, just in case a consult turns out to be necessary. You never know what some of these crazy prosecutors are going to do, even in a really robust case of self-defense. The other reason they called was to let us know So what happened here was there was a use of force event. Our member was faced with more than one aggressor, was armed with pepper spray, OC spray, and a pistol. The member has physical handicaps, so is exceptionally vulnerable to injury, multiple aggressors, and made the informed decision to not go to the gun, to instead deploy the pepper spray because of what he had learned from law and self-defense being a platinum member. And that solved the problem. And he told us that a few years ago, before he'd become a platinum member, he is utterly certain that he would have gone to the gun in that circumstance and shot and killed somebody and then be facing a potential murder charge. But he didn't have to do that because he knew the element of proportionality. He felt confident that he could solve the problem with his OC spray. And of course, he had his pistol at hand in case the OC spray didn't work, which is what we recommend, of course. And so this has all worked out beautifully for him. He won the physical fight, didn't have to go to deadly force, had the confidence not to go immediately to deadly force, and has put himself in a very, very defensible legal position. So not only did he win the physical fight, he's well positioned to win the legal fight as well. Now, the window is still open for potential legal liability here. We have to wait a bit before all the legal stuff is resolved. After it is resolved, he has offered to come onto the show and share his experience with the law self-defense community, do an interview on one of our shows. So if that happens, obviously I'll make you all aware so we can all benefit from the experience of this platinum member. All right, with that out of the way, let's dive into the meat of today's show, which is the Alec Baldwin shooting of Halyna Hutchins. Current updates. Here we go. All right, so we are back. So let's talk about what's going on with Alec Baldwin. Back on October, I believe it was October 21st, 2021. Let me just double check that date. Yeah, October 21st, 2021, on the movie set of the low-budget Western Rust, which was being filmed in New Mexico, around the Taos, New Mexico area. Alec Baldwin's the lead actor, part of the production team on this movie set. And the cinematographer was, believe it or not, a Ukrainian, or a woman of Ukrainian descent, Halyna Hutchins. And she's setting up some camera shots inside a little tiny church on set. And they're going to be filming Alec Baldwin drawing a revolver and firing a shot. So they're kind of rehearsing this. Alec Baldwin's in costume. He's got the revolver. He's doing some practice draws. He's asking Halyna Hutchins, is this how you want it? Is this how you want it? She's behind the camera. And the practice in Hollywood, well, first of all, before I even get to the practice, it is undisputed that Alec Baldwin was aware that he was holding a real, functional firearm capable of firing a bullet. He was interviewed by police after this event, and he told them, I knew it was a real gun. I've been trained on real guns. I know it wasn't my fault, he told them, because I know how to handle a real gun. And this was a real gun, and I've been trained on how to handle real guns. So there's no way to dispute. It's called a prop gun, as if it were an non-functional rubber replica of a firearm. It was not that. Obviously, it fired a real bullet into Halyna Hutchins. And more importantly, Alec Baldwin knew he was holding a real gun in his hand. And the practice in Hollywood, and I know this because I've read the SAG-AFTRA handbook on safety on sets, on movie sets. And I've also interviewed a friend of mine who last name is also Baldwin, Adam Baldwin, the actor. I've known Adam for many years, and he kindly came on the show. We did an interview with him and he's in a lot of movies in which he's handling guns. I think you all know. So he came on the show and he affirmed that the practice is you never actually point the muzzle directly at a human being on a movie set. Certainly not a real gun. you point it a few inches off to the side. So if the worst happens, if the gun were to discharge a live round, it doesn't strike a human being. Obviously, we know in this case, Alec Baldwin did point the muzzle directly at Halyna Hutchins because the round struck her, right? It didn't miss her. So Alec Baldwin's doing these practice draws, and suddenly the gun goes off. He will swear, he did swear on numerous statements to police and interviews on TV that he never pressed the trigger, never touched the trigger. He doesn't know how the gun went off. To him, it's just a complete mystery. We do have not imagery of the actual shooting, at least not that I've seen, but we do have imagery, photographs, video of him doing the practice draws immediately prior to the gun discharging. And in those practice draws, his finger is definitely on the trigger. I'll share some of those images with you. And the question, of course, is what kind of legal liability might Alec Baldwin have for having shot and killed Halyna Hutchins, a wife and mother, on October 21st, 2021. So I did some, the day after this happened, and that first week, I did some initial analysis of this event under New Mexico law, which is where this occurred, and as well as some more general legal doctrine. So let's start there to kind of provide a foundation, because I know a lot of you watching today's show were not watching in October 2021 and haven't seen that previous content. So we'll start with that. And I've done, let's see, let me pull this up. Oh, wait, before I do that, I am remiss. I am remiss on the grift. Folks, today's Law of Self-Defense show was brought to you by none other than Law of Self-Defense itself. You might consider becoming a member of Law of Self-Defense. There's a lot of benefits to being a member of Law of Self-Defense. One is that we only address comments and questions from our members who are commenting in the live chat of today's stream and every stream that we do. Members also get a transcript of every show for those of you who prefer to read rather than watch video. Plus, the transcript is downloadable. So you have a record of what you've learned in terms of specialized knowledge in use of force law, which can be critical if you're involved in a use of force event and you find yourself at trial and you need to be able to explain to the jury why your use of force decisions were reasonable. And the only way they could be understood to be reasonable was because of your specialized knowledge, what you learned in our content. Unless you can demonstrate you possessed that knowledge at the time you acted in self-defense, it's not admissible in court. So by being able to download these transcripts, you can effectively introduce those transcripts of the courses into court before the jury and educate the jury on the actual law of self-defense so they can understand why your use of force decisions were reasonable decisions and therefore lawful, and therefore they should acquit you of the criminal charges. Also, there's a lot of content we produce, especially our breakdowns of use of force videos, police body-worn camera videos, shootings caught on Ring cameras. We can't cover that stuff on YouTube because they just demonetize us. So all that kind of the most fun legal analysis that we do is for members only. There's lots of other benefits. You try it out for 99 cents for a 2-week trial, folks, and instantly get unlimited access to all our members' content, years of content, video, podcasts, written blog posts for 99 cents for a 2-week trial. And if you stay a member after the 2 weeks, it's still dirt cheap. It's only about 30 cents a day, less than $10 a month to be a Law of Self-Defense member. Try it out today. For just open up another tab on your browser right now, lawofselfdefense.com/trial, and then you'll be able to join the live stream, the member live stream of today's show right now while it's airing, and get your comments and questions answered in the chat. Again, lawofselfdefense.com/trial. So, yes, what I wanted to mention was I've been covering this. So this shooting happened October 21st, 2021. My first post on this, you can see in the bottom right-hand corner here, was October 22nd, 2021. And I've been covering it ever since. There's 6-7 blog posts here. There's more content here. Here's my interview with Adam Baldwin. Again, only Law of Self-Defense members will be able to access that here. So I've been doing coverage of this since it originally happened. And what I'd like to do is actually rewind the clock all the way to the day after the shooting, October 22nd, 2021, and go over some legal concepts that I think might be helpful for everyone to understand. So let me let me pump this up, as they say, and go through some of this. So we're sharing a tragic story out of New Mexico involving Alec Baldwin, who I'm sure we're all familiar with at this point, in the shooting death of Halyna Hutchins on the set. Halyna Hutchins, then 42 years old, a wife and mother, was killed. Also, a director, Joel Souza, 48 years old, was injured. The round that was fired, the single round, passed through Halyna Hutchins and struck Joel Souza, was actually recovered from just under the skin on Joel Souza's back. So Joel Souza was injured by the gunshot, but not killed. And of course, I got a lot of inquiries about this. One of the questions would be, what's the maximum potential legal liability for Alec Baldwin? And it would be involuntary manslaughter under New Mexico law, which is normally punishable by up to 18 months in prison and a $5,000 fine, which doesn't seem like a lot of time for involuntary manslaughter. In most states, the punishment could be substantially greater. But there we go. I can't recall now if there's firearm sentencing enhancement type of things for involuntary manslaughter. I think there are under New Mexico law, but I don't think they're applicable to Alec Baldwin's scenario. I think the prosecutor did originally bring those, but ultimately dropped them. And as I recall, my analysis was they were appropriately dropped. So there's various kinds of legal culpability, legal responsibility that can be asserted depending on the nature of the underlying act. And here we can think of the various options as accident, negligence, a concept called criminal negligence, and recklessness. So an accident is a bad outcome that was in some way triggered by you, but for which you ought to have zero responsibility, zero legal responsibility. And the zero legal responsibility is largely a function of the complete unpredictability of the bad outcome. So to illustrate, you have an elderly aunt, lives in an apartment. You go up to her apartment to visit, and she asks you, hey, can you move that bureau from one side of the room to the other side of the room? So you're a big, strong young man. So you pick up this heavy bureau, you pick it up from one side of the room, you move it to the other side of the room, you put it on the floor of the apartment, and unbeknownst to you, impossible for you to know, not apparent in any way, the floor joists on the other side of the room are rotten from termites, and the bureau falls through the floor into the apartment below, lands on another old lady, and kills her. What should be your legal responsibility for the death of that other old lady? Well, it should be zero, because this is a genuine accident. You were conducting yourself in a lawful manner. It was completely unforeseeable, unpredictable by you that a bad outcome would result. A bad outcome did result. Somebody died as a result of your conduct. But because it was unpredictable, unforeseeable, and of course there was no malice in your heart, in your mind, there's zero legal liability when there is a genuine accident of this type. Then we have negligence. Negligence occurs when you were also not aware, you were not consciously thinking that there's a potential bad outcome from what I'm doing, but you, a reasonable and prudent person in your circumstances, would have predicted the potential of a bad outcome. So you weren't consciously thinking about a bad outcome, but you should have been thinking about it. And an example of this might be someone who is driving too fast in the rain, or driving while looking at their cell phone, for example. And you're not thinking when you're doing that, hey, if I do this, I'm increasing my chances for an accident. That's not in your mind. But a reasonable and prudent person, a cautious person, would have been thinking that. And therefore, because you should have known of the risk, even though you weren't thinking of it, that creates negligence liability. Now, negligence liability is not enough for criminal liability. Negligence is only enough for civil liability. So it's not enough for prosecution, but it is enough for whoever you've injured to sue you in civil court, recover money for their damages. There's another concept called criminal negligence, but I'll come back to that in just a moment. First, I'd like to talk about the next higher level of mental culpability, which is recklessness. So negligence is where you're not consciously aware of the risk you're creating. Recklessness is where you are consciously aware of the risk you're creating. So you're intentionally creating a substantial and unjustified risk of, let's talk about death to another person. You ignore that risk and death results. That's a reckless homicide. That's involuntary manslaughter. That's what reckless manslaughter is, involuntary manslaughter. You never intended to hurt anybody, which would be voluntary manslaughter or potentially murder. There was no intent to hurt. But you knew you were creating a substantial and unjustified risk of death to another. You ignored that risk and death resulted. And the classic example of a reckless manslaughter would be drunk driving death. So you go to a bar, you get drunk, you get behind the wheel of a car to drive home. You're not intending to cause anyone's death. You don't want to hurt anybody at all. You just want to get home, go to sleep. So there's no intent to harm. But we all know that when you get drunk and get behind the wheel of a car, you're creating a substantial and unjustified risk of death to another person. And by engaging in that conduct, you're deliberately ignoring that risk. If you do run someone over and kill them, that's a reckless homicide, involuntary manslaughter. Now, some states may call it vehicular homicide, whatever, but the underlying legal doctrine is recklessness. The knowing creation of a substantial and unjustified risk of death, ignoring the risk causing the death, involuntary manslaughter. Now, there is a flavor of negligence that sometimes is referred to as criminal negligence that does. So step back. Where negligence only creates civil liability, recklessness is where you get to criminal liability. So now you can be prosecuted. There is kind of an intermediary here, a form of negligence that's referred to as criminal negligence, which seems weird, right? Because negligence is only good for civil liability, but now we're talking about criminal negligence. Well, criminal negligence occurs when you're like negligence, you're not consciously thinking about the risk you're creating. A reasonable and prudent person would be aware, so you should be aware, but you're not consciously thinking about it. So it's not recklessness, but you're engaged in negligence while you're handling an inherently dangerous instrument. Explosives, heavy equipment, chemicals, dangerous chemicals, and firearms. It's almost impossible if you kill someone unintentionally with a gun, because a gun is an inherently dangerous instrument, and we all know it is. You'd have to come from outer space, never have seen a gun before, to not know guns are inherently dangerous instruments. It's almost impossible to unintentionally shoot someone with a gun and not have criminal liability. I mean, can we think of a hypothetical? Sure, I guess. I mean, could it be an accident? So it was completely unforeseeable. Maybe if you were handed a box and told, carry this box across the room, put it on that shelf, and unbeknownst to you, there was a loaded gun in the box, and on the way, someone bumps into you, you drop the box, and it hits the ground, and the gun discharges. I guess that could be an accidental death while you're, quote unquote, handling a firearm. But obviously, you didn't even know there was a firearm in your possession under that scenario. With negligence, you can't really have a purely civil negligent death with a firearm if you know you're handling a firearm, because firearms are inherently dangerous instruments, and that automatically bumps the negligence up to criminal negligence. So it creates criminal liability. Most likely, of course, is your handling of the gun, because to cause a death to someone, you have to point it at someone and pull the trigger. On any modern normally functioning firearm, they don't just go off by themselves. They're not sentient. They don't make the decision to fire. You have to have pointed the muzzle directly at another person and operated the trigger to get the gun to discharge. That's going to be recklessness. The knowing creation of a substantial unjustified risk of death to another. So what was Alec Baldwin's situation? Accident, negligence, or recklessness? Well, it's not an accident, because it's not unforeseeable that if you point a gun at someone without ensuring that it's unloaded, that the gun could discharge and kill them. It's not negligence only civil liability because you know you're handling an inherently dangerous instrument. It's either criminal negligence or recklessness. And in both cases, the legal outcome would be the same. It would be involuntary manslaughter. Let's see. So that was pretty much the end of that analysis. That's where Alec Baldwin's liability comes from. I do have a more detailed, let's see. Look at New Mexico law. So let's take a look at that as well. Those were just the general legal concepts I wanted to cover that I wrote up the day after the event. This past January, so more than a year after the event, this past January, Alec Baldwin was in fact charged with manslaughter. Now, for more than a year, I'd been saying this looks like manslaughter to me every day of the week, twice on Sundays. And more than a year goes by with no criminal charge brought against Alec Baldwin. And finally, in January of this year, he's charged with manslaughter by New Mexico prosecutors. And so let's take a look at some New Mexico law. And the relevant facts for this analysis are really undisputed. Alec Baldwin was the person who was holding the gun, manipulating the gun that fired the projectile that killed Miss Hutchins. Uncontested. The gun discharged because the trigger was depressed and not because of some defect in the weapon. Now, in truth, I don't believe this element is required to establish involuntary manslaughter here. I think the facts, and we're going to go into the firearms examiner's report, indicate that Baldwin did, in fact, operate the trigger. But even if he hadn't operated the trigger, to my mind, the recklessness was established the moment he pointed what he knew to be a real gun at another human being without ensuring it wasn't loaded. I don't believe for an instant that Alec Baldwin would have pointed that gun in his hand, what he knew to be a real gun, at his own head or the head of his wife or the head of any of his several children without ensuring there was no rounds in the gun. You are creating an substantial and unjustified risk of death merely from the act of pointing the muzzle of a real gun that you have not determined has no ammo in it at another human being. Another fact undisputed, the muzzle of the weapon was pointed at Miss Hutchins by Baldwin. Obviously, she was struck by the round that came out. The gun contained a live bullet. Obviously, right? The gun fired a live bullet. Baldwin had the opportunity to inspect the weapon for live ammo before he pointed it at Miss Hutchins. He did. And by the way, he has decades of firearms training over his movie career on handling real guns on sets. And the Hollywood SAG-AFTRA guidelines say explicitly, safety is everybody's responsibility. You don't get a pass because there's other people on the set who also have safety obligations on the set. And there's nothing in New Mexico involuntary manslaughter law that says this applies to everyone except for Hollywood actors on a set. And also, I'm assuming that Baldwin did not intentionally want to shoot Miss Hutchins. So I'm assuming this was not a voluntary killing, that it was involuntary, unintended. So with those facts established, let's take a look at New Mexico law. So the New Mexico statute on involuntary manslaughter reads, manslaughter is the unlawful killing of a human being without malice. So it's not intentional. Involuntary manslaughter consists of manslaughter committed in the commission of a lawful act that might produce death without due caution and circumspection. That's it. Now, Miss Hutchins was obviously killed. It was not justified, of course. She wasn't attacking Alec Baldwin when this happens. We're presuming no malice, that he didn't simply want to murder her. There's no evidence of that. So that meets the conditions of this first sentence of the statute. Manslaughter is the unlawful killing of a human being without malice. So because it would have been unintentional, we're presuming voluntary manslaughter is off the table. So the key is whether Baldwin's pointing of the gun at Hutchins, and I think we'll see that he almost certainly pressed the trigger, although I don't think that's required, without first ensuring that the gun did not contain live ammo, was that the commission of a lawful act which might produce death, and that was done without due caution and circumspection. Well, again, we're dealing with a gun, so we're dealing with inherently dangerous instruments. Baldwin knew it was a real gun. He'd been trained on handling real guns for decades. He knows a real gun is always capable of firing a live round if there's a live round in the gun. And he had the opportunity to inspect and see if it was loaded with live rounds, and he chose not to do that. He chose instead to simply rely on what the representations of others or the job obligations of others, and death resulted. Now, there are, of course, in the handling of firearms, we have more than 100 years of gun safety doctrines built around the safe handling of firearms. The most common framework, really for practical purpose, the universal framework, is 4 rules of gun safety. These are them. All guns are presumed to be loaded until the person handling the gun personally verifies otherwise. And what that means, folks, is if I'm handling a gun and I check and I look and it's unloaded, there's no magazine, I check the chamber, slide goes forward. If I hand that gun to another person, they check. They just saw me check. They check for themselves. And if they hand it to yet another person, they check for themselves. If they hand it back to me, all in the space of a few seconds, when that gun comes back into my hand, I check again. Because otherwise, the gun is presumed to be loaded. Rule number 2, never point the muzzle of a firearm at anything you're not willing to kill or destroy. Never press the trigger of a firearm unless you intend for it to fire a bullet from the barrel. And of course, know your target and what is beyond your target. And the beauty of these 4 rules of gun safety is that you can't have a truly bad outcome unless you violate more than one of these. They're cumulative in that effect. So you can violate any one of these and not have a terrible outcome as long as you don't violate some combination of them. So you could not check to see that the gun's unloaded and the gun discharges, but as long as it wasn't pointed at something you're unwilling to kill or destroy, there's no real harm that results. Or you might fail to check that the gun's unloaded. As long as you don't press the trigger, the gun doesn't discharge. Does that make sense? You may press the trigger, but as long as the gun's not pointed at anything you're not willing to kill or destroy, there's no real bad outcome. You have to violate some combination of these 4 rules in order to get the kind of bad outcome we had in the death of Halyna Hutchins. And in that sense, these rules, there's a certain level of redundancy. So what happened with Alec Baldwin? Well, first, he pointed the muzzle at Halyna Hutchins. Obviously, the bullet struck her, so the muzzle was pointed directly at her. I think the evidence supports that he pressed the trigger, but frankly, the first violation of the rule of gun safety is all that's required. He failed to ensure that the weapon did not contain a live round. And the result is the unintended discharge of the bullet into Miss Hutchins, killing her. If he had only taken a moment to ensure there was no live round in the gun, this is the combination. Let's forget the press trigger for a moment. All you need is to violate 2 of the rules of gun safety, 2 of the 4, and you have the potential, a substantial potential, for an unjustified death of an innocent person. Even if you believe he never touched the trigger, he pointed the muzzle at her, he failed to ensure there was not a live round in the gun. That's enough for recklessness. That creates a substantial, unjustified risk of death. He would not have done that to his own head without checking to make sure there was not a round in the gun. And again, I think the evidence supports that he actually pressed the trigger. So how would the New Mexico jury instruction work? If Alec Baldwin was brought to trial, we had the trial, the jury is about to go into deliberations, but first they're instructed on the law. The jury instruction they would get on involuntary manslaughter would read like this. Ladies and gentlemen of the jury, for you to find the defendant guilty of involuntary manslaughter, the state must prove to your satisfaction beyond a reasonable doubt each of the following elements of the crime. That Alec Baldwin pointed a loaded firearm at Miss Hutchins and depressed the trigger. Again, I don't really think depressing the trigger is required here, but I think the evidence would support that. Firing a bullet into her. That's really uncontested. Alec Baldwin should have known of the danger involved by his actions. Well, he knows he's handling a real gun, and he's been trained for decades in the dangers of handling real guns. Alec Baldwin acted with a willful disregard for the safety of others, meaning he knows guns are inherently dangerous, and yet he pointed it at another human person deliberately. That's willful disregard. And Alec Baldwin's act caused the death of Miss Hutchins. Well, clearly it's the bullet that killed her. And of course, that this happened in New Mexico on or about the 21st day of October 2021. There's no reasonable jury that could fail to convict with that instruction on this evidence. And what about the fact that he didn't know the gun was loaded? He says he didn't know the gun was loaded, and I believe him. I don't think Alec Baldwin thought the gun was loaded, or he wouldn't have done this. So is that not knowing the gun was loaded, is that sufficient to clear him of liability? And the answer is no. We have New Mexico Supreme Court case law on this. And it reads, quote, of course, in a different case, but on the issue of not knowing the gun was loaded, quote, it could have made no difference to the trial of someone who was convicted on similar facts of a charge of involuntary manslaughter as to who loaded the gun. All that is necessary to establish for involuntary manslaughter by the use of a loaded firearm is that a defendant had in his hands a gun, which at some time had been loaded by whoever, and that he handled it without due caution and circumspection, and that death resulted. So under New Mexico case law, it doesn't matter who loaded the gun. It doesn't matter that Alec Baldwin didn't, that someone else must have. It doesn't matter. The gun's in his hand. He's responsible for what happens with it. And the fact that other people may have done other bad things may create legal liability for them too. But their legal liability does not relieve Alec Baldwin of legal liability. By the way, the reverse may be true. Alec Baldwin's misconduct may relieve other people of legal liability. Alec Baldwin's misconduct may relieve Hannah Gutierrez-Reed of legal liability. That's what her defense is arguing right now as we come up to trial, that his misconduct was an unforeseeable intervening cause that breaks her connection to the death of Halyna Hutchins. But the reverse can't be true, because Gutierrez-Reed's misconduct, whatever it might have been, is not a subsequent intervening cause from Alec Baldwin's misconduct. It didn't come after what he did. What he did came after anything Hannah Gutierrez-Reed might have done. So that other people may have done things wrong doesn't relieve Alec Baldwin of criminal liability. What he did may relieve other people of criminal liability, and we'll see that. And the fact that he's an actor and that there's an armorer and there's an assistant director, there's no exception in the handling of the knowing handling of a real gun. There's no exception for being a Hollywood actor that relieves you of criminal liability. Now, a good legal defense for Alec Baldwin would have been when he's interviewed by police the day of the event or the day after the event, if he had told them, holy cow, I had no idea that was a real gun. I thought that was a non-functional prop that was completely incapable of firing a real bullet. If he had said that, that would have relieved him of criminal liability, because then he would not have known, there would have been no recklessness, because he would not have known he was creating a substantial and unjustified risk of death. There would have been no criminal negligence, because he would not have known that he was handling an inherently dangerous instrument. And in that sense, being an actor who believes he's handling an inoperable prop, that would have relieved him of legal liability, criminal liability. But he told the investigators immediately, I knew it was a real gun, and I know how to safely handle real guns. I can't understand how this could have happened. Once he says that, he's liable for what happens with that gun when it's in his hand. All right, so why is this? Oh, and then the last thing is that interview I did with Adam Baldwin. Very, very good interview. I would encourage you. So the date of this blog post, for those of you, well, anyone can just go to lawofselfdefense.com/Baldwin, lawofselfdefense.com/Baldwin, and you'll get to this aggregated list of blog posts that we have on all this stuff. And you'll find the good Baldwin interview there. Now, I should mention, Adam Baldwin is not, I was going to say not related to Alec Baldwin. The Baldwin brothers, or Alex, Stephen, I believe is the third one. Those are three brothers. Adam Baldwin, not part of the Baldwin brothers. Now, Adam tells me that he is distantly related generations ago back in Ireland. There's some distant relation, but there's no meaningful relation between Adam and Alec in the current era. And of course, they're very different people, very different politics as well. Yeah, Adam is one of the few people who makes me feel small. I'm just over 6'1". That dude is huge. He's not one of these Hollywood actors where they have to use tricks to make him look tall or large. He's just a big dude. All right, so now I want to get into the recent motions that were filed here. Let's see. Yep, these are them. This is the first one. This was filed June 9th by the prosecutor. The defense had made a motion back in June to dismiss the charges against Halyna Hutchins. This is the defense, not for Alec Baldwin. Alec Baldwin, by the way, the manslaughter charge was dropped by prosecutors in April of this year. We'll come back to that in a moment. Halyna Hutchins, of course, is still going to trial on an involuntary manslaughter charge. And as you lead up to trial, your defense attorneys are filing all kinds of motions to try to make the charges go away or put you in a more favorable position for trial. And they had filed a motion to have charges dismissed against Halyna Hutchins for a whole bunch of reasons. That she was being preferentially prosecuted, that the prosecutors had engaged in various forms of misconduct, blah, 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 blah. We're not going to go over most of those. But we will cover one of the issues is the subsequent intervening conduct of Alec Baldwin and the fact that the charges had been dropped against him. So if you're going to drop the charges against the guy who fired the actual shot that killed, how can you maintain the same charge, involuntary manslaughter, against someone who has a much more tentative legal liability here? Like Halyna Hutchins, the armorer, never pointed a gun at anybody, certainly not at Halyna Hutchins. Halyna Hutchins didn't press the trigger on that gun, didn't fire that round. That's Alec Baldwin. Nobody has more proximate criminal liability here than Alec Baldwin, the guy who fired the shot that killed Halyna Hutchins. So if you're going to drop the criminal charges against him, how can you not drop the criminal charges against Halyna Hutchins, the armorer? That was an argument made by the defense. And this is a response to that argument by the state. So we're going to take a look at that in a moment. Before we jump into all that, let me take a quick look at the Law Self-Defense chat to see what else we have to cover. Oh, yeah, by the way, so I see here in a comment, Paul notes that Law Self-Defense member Paul notes that Alec Baldwin is anti-gun. Another reason he can't possibly argue that he did not know he was engaged in inherently dangerous conduct when he pointed what he knew to be a real gun at Halyna Hutchins without ensuring it was unloaded is that Alec Baldwin's actually on the board of a gun control organization whose reason for existence is that guns are inherently dangerous. All right, let's see where we are in the chat. Law Self-Defense member Tony says, comment, there's no way the armorer is more culpable than the shooter. I concur exactly. I concur 100%. Law Self-Defense member Zach says, when it comes to guns, complacency can literally be a killer. There are countless stories of cops for 20 years in the force shooting themselves in the hand or firing the gun in their home when cleaning it. Yes, that's why guns are inherently dangerous instruments. Let's see. Law Self-Defense member Paul says there's a video of a cop in a school classroom explaining gun safety and shooting himself through the foot. Yeah, I've seen that. That's the ATF agent. I wish I'd thought to pull that up. Law Self-Defense member Chuck says, are you going to look into the Quenisha Johnson case? The defense closing argument is today. She's claiming self-defense. I haven't taken a look at it yet, Chuck, but he helpfully provides a link. So the trouble with listening to the closing argument is I didn't watch any of the trial. So it would be difficult for me to evaluate the credibility of the closing argument. Most claims of self-defense are nonsense. Law self-defense member Zach said Baldwin spent how long telling the cops how educated he is about guns? Yeah. So he really should have kept his mouth shut, like any of us should. Never talk to detectives without a lawyer present, and probably not even then. Let your lawyer do the talking. But I'm sure what Alec Baldwin was thinking, what so many potential defendants think when they're talking with the police, is that it's like the old TV show Columbo. I don't know how many of you are of an age to know the TV show Columbo. Columbo was this bumbling detective TV series. Well, he presented as bumbling. He was, in fact, very smart. But because he presented as bumbling, the bad actors in every one of these TV shows that had killed someone, they were convinced they were way smarter than him, and they could talk their way out of being identified as the killer. And over the 40 minutes of the TV show, this bumbling detective, Columbo, would entrap them in their own words. They weren't smarter. They just thought they were smarter. And that's what Alec Baldwin was doing here. He's a big Hollywood star. He's a multimillionaire. And he's talking to what? Some hick town detectives? Surely he can talk them out of thinking that he has any criminal responsibility here. And all he did was dig a hole for himself. I guarantee you, if Alec Baldwin had not spoken to the police in a substantive way, retained legal counsel, that legal counsel would have said, you know, all we really have to do is have you say you didn't even know it was a real gun. Now, of course, that would be a lie. But, you know, up to the state. The state has the burden of proof, not the defense. Let's see. Okay, so let's take a look. Now, both of these, this response motion is like, I don't know. Let me take a look. I forget. It's 25 pages long. We're not reading this whole thing. A lot of this has to do with political stuff that I'm not all that interested in. It's just the defense raising every possible defense and argument they can for their client, and the prosecution, you know, waving a bunch of stuff away. But the key issue, the key question I wanted to touch on here was this question of how can you keep charging Hannah Gutierrez-Reed if you're not charging Alec Baldwin? And this is the way the prosecution addressed that particular issue. Let's see. The charges against Alec Baldwin were dismissed without prejudice. So in April, they dropped the involuntary manslaughter charge against Alec Baldwin, but without prejudice. With prejudice means they're gone forever. They can never come back. Without prejudice means, no, we can change our minds. They were dismissed without prejudice because a possible malfunction of the gun significantly affects causation with regard to Baldwin, but not with regard to Gutierrez. So what they're saying here is Baldwin's prospective liability is recklessness in the handling of the gun. That his handling of the gun was done in such a way that it didn't create a substantial unjustified risk of death. Now, what they're referring to is Alec Baldwin's claim that he never touched the trigger. If it was, in fact, a defect in the gun, they're arguing that the gun fired itself, then it's true that Alec Baldwin didn't touch the trigger, and that breaks the causation of his liability. Now, I think that's a BS argument, because I think merely pointing the gun at another person, right, is sufficient to create a substantial unjustified risk of death. That's why we don't do it. We don't pick up a gun, not ensure it's unloaded, and point it at our own head. I mean, I wouldn't do that even if I had ensured it was unloaded. But certainly, until we've ensured it's unloaded, we know it's capable of inflicting death, potentially capable of inflicting death. So the mere pointing of the gun without ensuring it's unloaded creates a substantial and unjustified risk of death. To me, the pressing of the trigger is just a bonus. Here, the prosecution seems to be buying into this notion that, well, you have to have the trigger press. I don't think that's true. But even if you believe it's true, so if you assume you have to have the trigger press for liability, they're saying here, well, we have reason to believe there may have been a defect in the gun. and therefore a trigger press was not required. So maybe he didn't press a trigger and didn't cause the shot to fire. The prosecution continues. If it's determined that the gun did not malfunction, that it did require a trigger press to fire the gun, charges against Mr. Baldwin will proceed. So if it was not a malfunction, we're going to bring charges again. The prosecution, it continues, anticipates making a final charging decision with regard to Mr. Baldwin within the next 60 days. Well, I have to point this out. This was filed with the court on June 9th, 2023. June 9th, July 9th, August 9th, that's 60 days. It's now August 25th. And the prosecutor's office has made no court filing or other formal declaration, even in the media, that I can find about a final charging decision with respect to Mr. Baldwin. In any case, the evidence overwhelmingly supports the notion that Alec Baldwin did press the trigger. Now, Alec Baldwin has excellent attorneys working on his behalf. And one of the things they're making a big deal out of is that this revolver was sent to the FBI for testing. And it's very common in where someone's claiming a shooting was unintentional, a shooting death was unintentional. The gun just went off. They always say that. The gun just went off. I don't know what happened. That they'll test the gun. They'll put like a blank or a primer only cartridge in the gun. And then they'll start whacking the gun with a rubber mallet. And what they're trying to do is see if the gun can go off from some impact other than a pressing of the trigger. And the FBI was doing this, very standard kind of examination. And they did it enough that they actually broke the sear of the pistol, the part of the pistol that would release the hammer to discharge the gun. But the gun never fired, even up to the point of an impact strong enough to break the sear. The gun still never discharged. So all their testing is consistent with, no, the gun couldn't fire itself, meaning the trigger would still have to be pressed. But Alec Baldwin's lawyers are saying, no, look, the gun was defective. It's broken. Well, of course, it was broken in the course of the testing. It wasn't broken when it was in Alec Baldwin's hands. And then the state commissioned a firearms examiner report that only recently was provided to the defense and resulted in yet another motion by the defense. And this is that motion. This was filed August 15th. So more than the 60 days after the July 9th filing by the prosecution, right? Just a couple weeks ago, a week or so ago. August 15th. And that's why this show was covering Alec Baldwin, is because of this recent filing. So let me pull this up. And this is where the Hannah Gutierrez-Reed defense is again making this argument about a unforeseeable intervening cause, meaning Alec Baldwin's handling of the gun that cuts off the criminal liability for Hannah Gutierrez-Reed. That's the argument they're making. And what they're asking for here is defendant's motion requesting jury instruction of causation. They're asking for a jury instruction. Now, this is still pre-trial, but pre-trial is where you define the legal battlefield for the trial. And so pre-trial, they're asking the judge to agree to give the jury an instruction about unforeseeable intervening causes. Because if the jury buys that, it would acquit Hannah Gutierrez-Reed, their client, of criminal liability. So this reads, the special prosecutors, meaning just the prosecutors, have previously stated that they had information that there was an alleged modification of the gun used by Baldwin on the rust set. In other words, the prosecutors have claimed, well, it looks to us like there was a defect in the gun that just made it go off by itself. So Alec Baldwin had nothing to do with the gun discharging. The prosecution indicated that they believed this impacted causation of the manslaughter as to Baldwin, but not as to Ms. Gutierrez-Reed, because a defect in the gun would have nothing to do with what her allegedly reckless conduct is. Her allegedly reckless conduct is she allowed live ammo on the set. and did not herself ensure there was no live ammo in the gun before it went to Baldwin. A defect in the gun has nothing to do with those things. Continuing, this was the basis for dismissal of charges against Baldwin without prejudice. We now have received the prosecution's gun report by their experts, Lucien Hagg and Mike Hagg. The Hagg report, and we're going to look at that in a moment, that's attached. By the way, for law self-defense members, both of these motions will be linked as resources or references in today's blog post of the show when the replay version goes up. So you can read we're only going to look at a couple pages of the firearms report. The whole thing's pretty interesting, but it's like 40 pages long, so we can't read the whole thing. I'm just going to jump to the end, their conclusion, for purposes of today's show. The Hagg report does not indicate any modification to the gun. The report further expresses that when parts broken by the FBI in testing were replaced, the gun fired as designed, meaning only when the trigger was depressed. The FBI had previously stated in its report that the gun functioned as designed before parts were broken during destructive testing. Evidence at trial will show that Ms. Gutierrez-Reed had asked Assistant Director Halls, had asked him that she be called back into the church where the shooting happened if Baldwin was going to use the gun at all. Halls did not call her back into the church. Halls was the person who actually handed the gun to Baldwin, which is not how it's supposed to be done. The armorer is supposed to be in total control of all the real guns until the armorer hands them to the actor. This was a low-budget set. Not everybody had a high level of expertise. And the church where it happened was very small, confined space. So maybe that's part of what led to all this. But Assistant Director Halls did not call her back into the church before the gun discharged. Had Hannah been present in the church, under no circumstances would she have allowed, one, Baldwin to perform the cross draw with his finger on the trigger. Two, she would not have allowed Baldwin to point the gun directly at another person. And three, the rounds in the weapon would have been checked again to make sure they were dummy rounds and not live rounds. So, of course, this is Gutierrez-Reed, defense attorneys, arguing, hey, these checks did not happen, not because of the fault of our client, but because of the fault of other people. Continuing, Baldwin pointing the gun at Ms. Hutchins and pulling the trigger are independent intervening causes. In an uninterrupted sequence of events, Hannah would have been called into the church to perform her job as the armorer on the film. Hannah had no knowledge the gun would be used in a church scene, let alone be pointed at a person. The Hagg report specifies that the trigger had to be pulled and rules out certain types of accidental discharge. Quoting now from the report, quote, although Alec Baldwin repeatedly denies pulling the trigger, given the tests, findings, and observations reported here, the trigger had to be pulled or depressed sufficiently to release the fully cocked or retracted hammer of the evidence revolver. If the hammer had not been fully retracted to the rear and were to slip from the handler's thumb without the trigger depressed, the half cock or quarter cock notches in the hammer should have prevented the firing pin from reaching any cartridge in the firing chamber. If these features were somehow bypassed, a conspicuously off-center firing pin impression would result. Close quote. Continuing now with the defense motion, Ms. Gutierrez-Reed is requesting a ruling in advance of trial that these jury instructions be given as jury instructions on causation, which are copied in full below. And I'm not going to read the full jury instructions. I'll just note that they're informing the jury about that the misconduct of the defendant to result in a guilty verdict had to have been uninterrupted by an outside event. And of course, Hannah Gutierrez-Reed here is arguing that whatever culpability she might have, it was interrupted by an outside event, the conduct of Alec Baldwin. And the key part of the second jury instructions requested is that Hannah Gutierrez-Reed can only be found guilty if her conduct that the jury cannot find her guilty if Alec Baldwin's conduct constitutes an intervening cause that breaks the foreseeable chain of events So the whole paragraph here, if you find the negligence of a person other than the defendant, so Alec Baldwin, rather than Hannah Gutierrez Reed, was the only significant cause of death or constitutes an intervening cause that breaks the foreseeable chain of events, then the defendant is not guilty. So that's what the defense is going for here, that jury instruction to the jury. Then we get to the medical examiner's report. Very long. I'm not going to read the whole thing here. I'm just going to jump to the end, the conclusions, part of which was just quoted in the motion for those jury instructions. But again, I will link this report for law self-defense members. Another benefit of being a law self-defense member, folks, is you get all these additional resources that we don't put on YouTube or Twitter or Rumble. So you might consider becoming a member for just 99 cents for a 2-week trial, unlimited access to all our members-only content, transcripts of the shows, these additional kinds of resources. 99 cents for 2 weeks, 200% money back guarantee. It's a negative risk proposition, folks. And after the 2 weeks, it's only about 30 cents a day to be a member, less than $10 a month to be a law self-defense member. So back to the, and of course you can do that at lawofselfdefense.com/trial for the trial membership. All right, so back to the firearms examiner reports. There's a blank round there. There's also dummy cartridges involved with holes drilled in them. So you can tell even tactilely that it's a dummy round. And let's get to the end here. So the conclusion, the fatal incident. From the firearms examiner's report that the defense was just given recently. From an examination of the fired cartridge case and the operationally restored evidence, so they replaced the broken parts, the parts the FBI broke inside the gun, they replaced them with parts that were identical before they were broken. And the operationally restored evidence revolver, this fatal incident was the consequence of the hammer being manually retracted to its fully rearward and cocked position, followed at some point by the pull or rearward depression of the trigger. The only conceivable alternative to the foregoing would be a situation in which the trigger was already pulled or held rearward while retracting the hammer to the full cock position. Although unlikely and totally contrary to the normal operation of this single-action revolver, such improper handling would result in the discharge of a live cartridge. So the point here is you had to have both things. The sequence doesn't matter. The hammer cocked and the trigger depressed, or the trigger held rearward and the hammer cocked and released. Continuing, at the moment of discharge, the evidence revolver was pointed at Halyna Hutchins, behind whom was Joel Souza, both of whom were struck by the fired round. The bullet passed completely through Halyna Hutchins, then nearly passed through Joel Souza, ending up just under the skin of his back, from which it was removed at the hospital. Although Alec Baldwin repeatedly denies pulling the trigger, given the tests, findings, and observations reported here, the trigger had to be pulled or depressed sufficiently to release the fully cocked or retracted hammer of the evidence revolver. If the hammer had not been fully retracted, and this part I read from the motion, but I'll read it again. If the hammer had not been fully retracted to the rear and were to slip from the handler's thumb without the trigger depressed, the half cock or quarter cock notches in the hammer should have prevented the firing pin from reaching any cartridge in the firing chamber. If these features were somehow bypassed, a conspicuously off-center firing pin impression would result, which didn't happen. 3 frames from one of the videos submitted to this writer on April 19th, 2023, and 2 frames from a second video received on that same date are useful in evaluating his account, Alec Baldwin's account of the incident. Figures 21A, B, and C show Mr. Baldwin cocking the silver-colored hammer of a long-barreled revolver with his right thumb, ending up, I see. Cocking the hammer, should be a comma here, with his right index finger ending up on or near the trigger. This description of the revolver in the video corresponds to the evidence revolver. And so here's Let's make it bigger so we can all see. There's his finger near the trigger, certainly. There's his finger. It looks like it's through the trigger guard here. There's his finger. Again, looks like it's through the trigger guard here. And then two more figures. Figures 22A and 22B, taken from the second video, show two frames from two fast draw demonstrations in which Mr. Baldwin's right index finger is inside the trigger guard and either on or near the trigger. His thumb is not in contact with the hammer. So you can see his fingers through the trigger guard, curled around the trigger. And folks, if you've never handled one of these single action revolvers, the trigger is quite different than a modern double action revolver, which tends to be a fairly broad, wide trigger blade, a flat surface against your finger. On these single action revolvers, the trigger is often very, very thin. And of course, when the hammer is cocked, the amount of pressure required to release the hammer is very, very slight. Index on the trigger, index finger on the trigger. Again, so if this is what caused the gun to discharge, Hannah Gutierrez-Reed's lawyers are saying, hey, him pointing the gun at Halyna Hutchins, cocking the hammer, pressing the trigger, which the state's firearms examiners are saying had to happen in order for the gun to discharge, without calling in Hannah Gutierrez-Reed, the armorer, as she'd requested, into the church before this gun was handled, so that she could prohibit him from pointing it at Halyna Hutchins and ensure the gun was still unloaded. This conduct was an unforeseeable intervening cause that ends the liability, the criminal liability of Hannah Gutierrez-Reed's, and shifts it entirely onto Alec Baldwin. That's the defense argument of the Hannah Gutierrez-Reed crew. That's why they want these jury instructions about an unforeseeable intervening cause. All right, folks. So let me take a look at the law of self-defense comments and chat questions. Now, again, we only answer comments and questions from law of self-defense members. So you might consider becoming a law of self-defense member. 99 cents, folks, for a 2-week trial, about 30 cents a day, less than $10 a month after that. Take advantage of that at lawofselfdefense.com/trial. Let's see. Where did I leave off? About here, when I was talking about Colombo. Let's see. Law self-defense member David says he didn't think it was loaded. Alec, he didn't want to kill. Well, no one's claiming it was an intentional killing. Halyna directed the action. Alec responded to her will. Well, you don't lose criminal liability because someone else tells you, hey, point that gun at me and pull the trigger. And then it goes off. That's still your fault because you're handling an inherently dangerous instrument. You don't lose liability. And by the way, there's no evidence that Halyna Hutchins said, point the gun at me, cock the hammer, and press the trigger. That's just pure speculation. There's zero evidence of that. David obviously is an Alec Baldwin supporter here. Again, he writes, the failure of the armorer, reckless to her core, was the killer of poor Halyna, introducing bullet to the bore. She may be criminally liable for involuntary manslaughter. Halyna Hutchins may be. There's a robust argument to be made there. But she can't be more liable than Alec Baldwin. Let's see. Law self-defense member Zach says, question, the gun that was used, doesn't that have a dual action trigger? So the only way for it to fire is to pull the trigger. Well, the only way for it to fire is to pull the trigger. That's what the firearms examiner determined, but it's not a double action trigger. So a double action revolver, it's called double action because the trigger does two actions. As you press the trigger, the trigger cocks the hammer, so you don't have to cock it manually. And then eventually, as you continue to press, the trigger also releases the hammer to fire the shot. So you don't have to cock the hammer yourself, just operating the trigger does both actions. Cocking the hammer, releasing the hammer, the trigger does it all. A single action trigger has one function. All it can do is release the hammer. So the hammer has to be manually cocked first, and then it can be released by the trigger. But if the hammer's down, pressing the trigger does nothing. That single action trigger is not capable of cocking the hammer on your behalf. Law self-defense member Dave asked, was the trigger pull pound rate ever revealed? It might be in that firearms examiner report, folks, but the weight you would need for a single action trigger is maybe a couple pounds, maybe 3 pounds. Very, very light. I mean, on a good quality, on my Wilson Combat 1911 pistol that I carried for 25 years for personal protection and shot 100,000 rounds through in competition, the trigger pull on that single action 1911 is about 3.5 pounds, which is not an amateur's trigger pull. I think on most single action revolvers, it's actually lighter than that. So it doesn't matter for legal culpability purposes. Let me put it that way. Let's see. Law self-defense member Zach says, well, according to Alec, there was no need for a highly trained, qualified armorer to be on set because Alec himself is well trained in guns. We know that because he told the cops. That's all true. Let's see. Law self-defense member Andrew asks, is this volume of documentation and back and forth typical of any gun or hypothetical case, including good guy self-defense cases? I mean, it varies a lot. I mean, frankly, the amount of documentation and filings back and forth is largely a function of how many resources the parties have to bring to the fight, the legal fight. The prosecution effectively has infinite resources. Most of the time in criminal cases, the defense has very few resources. That's obviously not the case here. Alec Baldwin's a millionaire. He's hired millionaire grade lawyers to act in his defense, and they're doing a great job. They're doing a great job. So they are going, I expect they are going to miss nothing. And I would think Hannah Gutierrez Reed's lawyers are also very high level. I mean, she won't have a lot of money, but her dad probably has a lot of money. So everyone seems to be doing a good job here. And I would expect no misses here, no missed opportunities, given the quality of lawyers and the resources being brought to bear for the legal fight. Law self-defense member DJ says, I don't understand why a real functional handgun was introduced to the scene in the first place. Well, I can tell you that. The reason the movies use real guns is because they want the guns to look real on set. And the cost of manufacturing a gun that looks real and is not a real gun is a multiple of the cost of a real gun. You have to understand there's companies that exist to provide Hollywood with real guns for their sets. And they probably provide armorers and all that other stuff too. But you walk into a gun store, just buy a gun. To have a series of fake guns, someone would have to design and build those, and nobody wants to make that effort. So what you tend to see on movie sets, and listen, I don't claim to be have spent my life in Hollywood, but I know some Hollywood actors. I know Adam Baldwin. I have worked on TV productions involving guns, and so what you tend to see is the extreme ends of the spectrum. The extras who are not going to be in close-ups, they're given very primitive rubber guns. They're like blue guns. You've probably all seen blue guns you might use for training purposes, but of course they're painted black, so they look black. And because they're distant from the camera, the details don't need to be very fine. I mean, sometimes you pick up one of these like a rubber AR, you look at it and it's been dropped, so the barrel's crooked. I mean, they don't look, on any kind of close inspection, they don't look like a real gun, but from a distance, they're fine. They're adequate. But if you were to do a close-up with one of those, it would just look like a rubber gun. It would look ridiculous. It would, I don't know why Siri turns on like that. If you were to do a close-up with a rubber gun, it would look ridiculous. So what the movie industry has always done is just use real guns, which look like real guns, and try to ensure safety on the set. It's just the easiest way for them to go. That's why real guns are on movie sets all the time. That's the norm for the leads any kind of close-ups, it's going to be a real gun. There's rare exceptions. There have been a few times when I've been watching TV shows in particular where budgets are more constrained. This used to happen with that TV show, The Shield. If you're familiar with The Shield, the corrupt cops TV show, every once in a while I would catch a scene there where somebody would have a gun and you could see from the muzzle of the barrel that it wasn't a real gun or some other detail. It was some kind of air gun or it wasn't quite real. So they may try to get away with that kind of thing. But most of the time on movies, now cases like this may change that paradigm. And of course, in 2023, we have like BB guns. Like there's a shooting I'm going to cover soon for law self-defense members because it involves somebody being shot. But police officer approaches a 15-year-old who has an apparent Glock 17 in his waistband. And the 17-year-old pulls the Glock 17 out of the waistband and gets shot and killed by the officer. And I've seen close-ups. I have the crime report of that apparent Glock 17. It turns out it was a BB gun. But man, I've handled a lot of Glock 17s. And this BB gun looks exactly like a Glock 17. I mean, the detail is unbelievable. So maybe movie sets will start using that kind of thing. Use a BB gun instead of a real gun. Another problem they run into, though, is at some point in the action, they generally need the gun to fire, to make a flash and cycle so it can fire more than once. And BB guns won't do that. So not in a realistic way. So they use real guns with squib rounds for that effect. It's up to the industry. I have been involved with TV shows where I've been a consultant on a TV show where were they real guns? I think they were real guns, but they didn't use squibs. So all the muzzle flash and all the sound was done post-production because I would send clips of early cuts of the filming where they didn't have those effects in yet. And the bad guys just, they're just pointing the gun around. And then I got the clips from the post-production and suddenly there's a muzzle flash and a gunshot sound. Let's see. Oh, I guess someone tells me that the David character was being satirical. Let's see. Looking at the chat for questions, comments. So law self-defense member Andrew says, can't they remove the firing pins or other related parts? They could, but then the gun wouldn't be capable of firing the squibs that they want. All right. So, folks, I think that is everything I wanted to cover today. So I don't have shows scheduled explicitly for next week. I actually have more shows in the pipeline that I could do next week. But I have a couple of road rage shows. I have that 15-year-old the BB gun show that I'll probably do. A show illustrating that there's always another witness. You may think you're alone with that aggressor, and there's nobody watching what you're doing in self-defense, but there's almost always another witness. Let's see. Couple of other cases. So I'll schedule stuff this weekend and then put them up online so you can see what's coming. But I think for this week, it's Friday. It's Friday, man. Weekend is coming. So please have a safe and happy weekend. And remember, if you carry a gun so that you're hard to kill, that's why I carry a gun, so I'm hard to kill. That's why I carry a knife. That's why I carry pepper spray. That's why I practice Brazilian jiu-jitsu. I do all those things, gun, knife, pepper spray, jiu-jitsu, because I want to be hard to kill. I want my family to be hard to kill. Well, if you want to be hard to kill, if you want your family to be hard to kill, and that's why you equip yourself to use force in defense of yourself and your family, you also owe it to yourself and your family to make sure you know the law so you're hard to convict as well. Until next time, I remain attorney Andrew Branca for Law Self-Defense. Stay safe.